Mr. President, Your Excellencies, good morning. If it pleases the court, my name is Greatness Eyonsa Essien, and I am appearing with my co-counsel, Chidera Royal Nwokuku. Together, we represent the applicant. Thank you very much. Your Excellencies, I shall address the court on the procedural issues of jurisdiction and admissibility, as well as Merit A for the next 13 minutes, while my co-counsel, Chidera Royal Nwokuku, shall address Merit B, C, and D for the next 16 minutes. Your Excellencies, we would like to reserve 3 minutes for rebuttals. With your kind permission, Your Excellencies, may I proceed? Thank you very much, Your Excellencies. Your Excellencies, with regards to the issue of jurisdiction, Article 3, Sub 1 and 2 of the protocol mandates this court to conduct a preliminary examination of its jurisdiction, and the court must satisfy itself that all the elements of jurisdiction are present. Your Excellencies, in the case of Miriam Kuma versus Mali, the court held that it must satisfy itself that it has the material jurisdiction, personal jurisdiction, temporal jurisdiction, and territorial jurisdiction. Your Excellencies, in this case, we submit that all the elements of jurisdiction are present. However, for time constraints and for avoidance of loquacious prolongations, the issue of jurisdiction that is contested by the respondent state is that of personal jurisdiction. And this is captured in paragraph 6 of the compromise, where the respondent says, withdrew its declaration it made under Article 34, Sub 6 of the protocol. Your Excellencies, we would like to invite this court to the case of Ngabiri versus Rwanda, where Honorable Justice Ramadhani, between paragraph 29 to 33 of the court judgment, stated that a withdrawal takes effect 12 months after it has been deposited with the Commission. Of course, Your Excellencies, the rationale behind this is to prevent abrupt disruption of judicial process with regards to cases already filed before this court. Your Excellencies, we submit that the withdrawal in this case should take effect 12 months after it has been deposited with this court, and by mathematical precision and exactitude, it is the 8th of August 2025. Your Excellencies, if this court is unpersuaded by this argument, we submit that the withdrawal is invalid because it defeats the purpose and intent of the African Charter, which is to promote and protect humans and people's rights. Your Excellencies, it is our argument that by making the declaration under Article 34, Sub 6 of the protocol, it vests Equitanians with the right to get and obtain remedy before this court in situations where these rights, these remedies cannot be obtained in the local court at Equitania, the domestic court at Equitania, and withdrawing from same would amount to denying Equitania the right to remedy before this court. Your Excellencies, we therefore submit that the withdrawal is invalid as it defeats the purpose and intent of the African Charter.
Just to probe further on the submissions on the invalidity of the withdrawal, isn't it agreed in practice under international law that states must voluntarily consent to being bound by any treaty obligation? I'm struggling to understand how you are insisting that a state party that has voluntarily signed up to a treaty and made a declaration should be prevented from withdrawing that declaration if exchanges might.
Thank you very much, Your Excellencies, for that question. Of course, this would lead me to my second point, or to my third point, which is the fact that this is the strongest argument that would be put forth by the respondent states. However, Your Excellencies, would like to draw the mind of this court to the quote by Franklin D. Roosevelt, which was adopted by the ICJ in the Barcelona Tractons case, where the court stated that freedom is the supremacy of human rights everywhere. Of course, at every point in time, this court should always prioritize human rights over the state sovereignty. And of course, over time, this court, over time in litany and plethora of cases, have prioritized human rights over state sovereignty. Your Excellencies, we have the case of Amad Diallo versus the Democratic Republic of Congo, as well as the case of Good versus Botswana. And Your Excellencies, in this case, we submit that even if we recognize the fact that the respondent state has the right to state sovereignty, however, the state should always consider the human rights of persons and should always prioritize same. Thank you very much, Your Excellencies. Your Excellencies, having stated this, the question that is begging pathetically before this court for answer is, if this court should find that it has the personal jurisdiction to hear this case, what would be the fate of the friendly shelter children who are looking up to this court as their last hope? What would be the fate of the girls in Equitania who have been violated, sexually abused, and are crying to this court for justice? Of course, this court should always recognize the fact that as much as it is a court of law, it is also a court of reasoning. And we urge this court to find that it has the personal jurisdiction to hear this case. Your Excellencies, with regards to the issue of admissibility, Article 6, Sub 2 of the protocol mandates this court to rule on admissibility of cases. Your Excellencies, by virtue of Article 56, Sub 5 of the African Charter, it states that a matter is inadmissible if it does not meet its requirement. Your Excellencies, we submit that in this case, the issue of admissibility in contention is that of local remedies. Of course, I would like to draw the attention of this court with a pencil to the case of African Commission versus Libya, where the court stated that local remedies must be exhausted up to the apex court unless they are unduly prolonged. Your Excellencies, in this case, we submit that with regards to the children found on the streets, local remedies were not available because there was no prospect of success owing to the applicant's standing. Your Excellencies, regarding the children at the friendly shelter, we submit that local remedies were unavailable because there was no prospect of success, as their rights, or the rights they sought to enforce within the courts in Equitania were unenforceable under the Equitanian laws. Your Excellencies, we submit that with regards to the Johnson's family, local remedies were not available due to undue prolongation, as up till this moment of filing this application before these courts, the courts in Equitania are yet to determine on the merits of the issue of the deportation of Mr. Johnson. And we submit that local remedies were not available due to undue prolongation. Thank you very much, Your Excellency. Your Excellency, this question has been answered by paragraph 14 of the compromise, where it stated that the matter was filed at the High Court but was dismissed for lack of diligent prosecution. Your Excellencies, on appeal, we got judgment in our favor, but the respondent could not get judgment in their favor because hearing notices were not served on us. And Your Excellencies, the respondent have appealed to the apex court, but the matter is yet to be determined up to date. Now, the answer to the question is that regarding the merits of the issue, it is yet to be resolved by the respondent state, by the court in Equitania. And the fact that the merits of the issue is yet to be resolved by the court in Equitania, it amounts to undue prolongation, Your Excellencies.
So you're saying that immediately because the merits have not been resolved, undue prolongation relates to a matter of time. My question is, why 2 years is too long a time? Okay. Is there any specific set of facts in this case that should have prompted the state to act expeditiously? Because one could say that 2 years is a reasonable time in which you have a case resolved in court. Even this court will usually take more than 2 years to resolve cases that is submitted before it. So what is peculiar about that particular case that is 2 years, too long time?
All right. Thank you very much, Your Excellency. Your Excellency, what makes this case peculiar is because the deportation of Mr. Johnson is on the line. This is someone who has been in Equitania since 2016, and he has been served with a notice that we consider that it is discriminatory, which will be argued by my co-counsel, Chidera Royal Nwokuku. So we submit that while this particular case is peculiar, why 2 years is too long, or why 2 years amounts to undue prolongation, is because his deportation is on the line, Your Excellency. Thank you very much, Your Excellency. Your Excellency. Okay.
You made a submission before that regarding the situation of children on the street, the local remedies not available. The text informs us that Equitonia is enacted in the Children's Act, so this should give you the legal basis for these rights to be enforced before the court. So what's your response to that?
Sorry, I did not get your question.
You submitted that local remedies regarding the situation of children on the street were not available. Thus, they could not be exhausted locally, which is why you are approaching this court today. And now my question to you is, Equitonia enacted the Children's Act with some key provisions on issues of children, and that should then give you a legal basis for those rights to be enforced domestically. So why couldn't you then approach the domestic courts regarding the situation of children on the street and prefer to come straight before this court?
Thank you very much, Your Excellency. Your Excellency, this question has been answered in paragraph 10 of the compromise, where it stated that the applicant, we approached the trial court in Equitania, but however, the court dismissed our case because they said we did not have the standing to institute the matter before this court, and hence my submission with regards to admissibility of the case of the children found on the street was that there was no prospect of success to enforce their rights owing to the applicant's standing. Thank you very much, Your Excellency. Your Excellency, quickly on merit A, it says, okay, Your Excellency, having discovered that my time is up, I'll plead this court for just 3 minutes to argue on merit A, if this court would grant me such time.
You have 1 minute to roll.
Thank you very much, Your Excellency. Your Excellency, with regards to merit A, it is our submission that the handling of the children found on the street contravenes the African Charter and other relevant human rights instruments. Of course, our first ground for challenging this is with regards to the violation under Article 5, with regards to the respondent state responsibility to protect these children under Article 16 of the ACRWC, and that the punishment meted out on the male staffs was disproportionate. Of course, this court would not grant me the latitude of time to adequately expound on these issues, but Your Excellencies, we would just love to state that with regards to the violation under Article 5, we submit that the children found on the street were the respondent state violated the rights of the children found on the street, as this was captured in paragraph 10 of the compromise, where the girls at the detention facility complained of sexual harassment. Your Excellencies, on the second standpoint, which was the violation under Article 16, the provision of Article 16 of the ACRWC mandates states to take legislative steps to enforce, to domesticate laws, and the respondent states have ratified litany and plethora of laws, but however, none of these have been domesticated, and the fact that they've not domesticated any sexual law, any law against sexual harassment, renders them liable. And lastly, on the issue of disproportionality of punishment, we submit that the punishment meted out on the children, on the male staffs, was disproportionate, as the essence of criminal law is to punish persons for crime. We submit, Your Excellencies, that a crime as heinous as sexual abuse, a crime as heinous as sexual harassment was the respondent states gave them administrative leave. And our submission is that it is not proportionate.
Just one last question, Council, before you the time is up. Regarding the situation of children on the streets, these are unaccompanied children, they do not have families. The government of Equatoria placed them in that safe shelter as an alternative care. Could you just explain to this court how that is a human rights violation?
All right, thank you very much, Your Excellency. Your Excellency, we recognize the fact that, of course, we concede the fact that the respondent state was right in placing them under a detention facility, as that was care, as well as they provided food and clothing and shelter to them. But however, Your Excellency, our submission is that with regards to the girls, of course, the respondent state failed in its obligation to protect them. And of course, the girls are also part of the children found on the streets. So, Your Excellencies, we submit in this case that they are liable for the violations. Thank you very much, Your Excellency. Your Excellency, quickly before I resume my seat, I would love to rely on the maxim, argumentum ab authoritate et fortissimum et in lege. Arguments drawn from authorities are the strongest in law. And in line with our arguments that we've canvassed before this court, we urge this court to resolve the issue of jurisdiction, the issue of admissibility, as well as merit A in our favor. Your Excellencies, may I invite my co-counsel to address on merit B, C, and D for the next 16 minutes.
Thank you, Counsel.